Thank you. Okay, 1540 is a bill that you all have seen 3 years in a row. It passed out of here 14-1, 15-0, 11-3. Came out of the Senate 39-1 last year. There's one change to it. Or, I'm sorry,
make it better or worse?
One amendment needed and one change. So the amendment is, I've talked to the Supreme Court, and in light of some form changes they've made, I'd like to strike 308 through 312, which is some of the new language.
308 to 312. Is there a motion to strike that language? So moved. This is translation.
Yeah, that takes away a fiscal impact, and the Supreme Court didn't really like it.
All right, it's been moved and seconded to strike 308 to 312. All in favor signify by saying aye. Aye. All opposed. That language is stricken.
Thank you. The only change, sorry, Mr. Quagliato has a question.
Mr. Chair, I believe that language also needs to be struck on 134 to 138.
That's true.
All right, is there a motion to make that amendment? It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed. That language is stricken.
Okay, and with that change, the only other difference in this bill besides the ones the committee has approved before is on lines 22 and 23. I added a provision to this that says that if a protective order is appealed to circuit court, that it has to be expedited on appeal, which is consistent with how protective orders are treated in the district courts. At least in my experience in Northern Virginia, the courts will sometimes take as long as 6 weeks to docket a protective order appeal, which is just too long. And I believe that everybody I've spoken to is okay with that change who does protective orders.
Mr. Chairman.
So this requires it to be docketed within 48 hours?
Of the appeal. Of receipt, 48 hours of receipt of the appeal.
Mr. Chairman.
Senator McDougal.
So if you are found to be covered under protective order, you have 10 days in which to note that appeal. So somebody a week or so ago is found to be covered by protective order on Friday, the last day, or this, let's say last Thursday, they go into district court or juvenile court, because it could be either, note that appeal, that court sends it up on Friday afternoon, and it's not docketed over the weekend, they've missed the 48 hours, right?
Close. What happens is, once you note your appeal, the district court clerk actually doesn't like immediately carry the file upstairs. Sometimes it takes a day or 2 or 3 or a week, and once the papers are received by the clerk, the actual file is received, they need to give it a case number, because sometimes it goes in a big stack of stuff, and they don't give it a case number, so you can't do anything with it. This just requires to be given a case number, not put on the docket for a hearing, but just given a case number so somebody can do something with it.
Mr. Chairman.
Senator McDougal.
So, well, let's say I have an efficient district court clerk, because I'm sure every one of mine that I come in contact with are extremely efficient. They get that appeal written notice from the subject of the complaint. They hand walk it upstairs to circuit court, give it to a circuit court clerk on Friday afternoon or Thursday afternoon, last Thursday. Have a 4-day weekend. Wouldn't you at least want to say 48 hours, like 2 business days?
Sure, it's fine.
I mean, because right now you have it, if somebody gets on Friday,
right.
If it's not done by Sunday,
That's fine. If you want to do that, that's fine. I'm just looking for it to get a case number, not actually go on a docket for a hearing.
Mr. Chairman.
Senator McDougal.
Could the Supreme Court come up and say, and maybe Mr. Dix, does docketed mean the same thing everywhere?
I can tell you Mr. Dix looked at all my bills for a day, and he left after he told me he was cool with all of them.
Except he's standing right there.
Yeah. All right, there he is.
He came back just to tell us that docketed means something similar or different in every circuit court.
Mr. Chairman, I did spend a lot of Sunday looking at Senator Sherfield's bills, but I would say that the 48 hours on a business day makes good sense to us, and if it says assigned a case number, that would be more appropriate, I think, as opposed to docketed.
Okay.
You want to make that?
Mr. Chairman, before I make the motion, the Supreme Court is back there. I don't know that they're excited to come forward, but I'd love to hear from them.
Yeah. Good morning, Mr. Chairman.
Good morning.
Members of the committee, Alyssa Patton with the Office of the Executive Secretary. I would defer to Mr. Dix as to the circuit court clerk's docketing procedures, but I don't see any particular problems with the amended language that's been proposed.
All right.
Mr. Chairman, I have a
All
question.
right, the amendment's been moved and seconded. Does your question go to the amendment?
It does. What's the difference between docketing and assigning a number? Aren't they the same? I thought when they docketed it, they assigned a number.
Mr. Chairman, I would say to Senator Edwards, I think that it means different things to different people. I don't know that it's a defined term, but everybody knows what it means to assign a case number, which means the case is opened, which is what the Senator Servell's language is trying to get to.
Mr. Chairman,
Senator
as I
Edwards.
recall, docketing is a technical legal term. For example, if you take a general district court judgment and you have to docket it in the clerk's office in order for it to be a lien on real estate. That's just one example.
So, Mr. Chairman, I would say that when you docket a document for recordation and a judgment, or you docket a hearing, there's a number of ways that docketing is used. Here, it's not defined. I think the easier way, since we're all talking about the same thing, is assigning a case number.
All right.
Yeah, I'm fine with
there's- The motion to amend's been seconded. It's before us. All in favor of the amendment signify by saying aye. Aye. All opposed. All right. The amendment is
Okay. And with
adopted.
that change, the bill is otherwise in the same form. This committee's approved it 3 times, and the Senate approved it 39-1 last year. The same people have an objection to it as have had it in the last 3 years, and I think they're here to speak.
All right. And the other thing that this bill does is it requires the court to include in its order the basis for the protective order summary.
If there's no affidavit.
All right. Okay. All right. Those who wish to speak in opposition to the bill?
Good morning, Mr. Chair. Sushila Varkey on behalf of Virginia Poverty Law Center. I've expressed my objections in the past because of the requirement of a summary of allegations and findings might have a chilling effect on judges actually doing that. And that would prevent victims from being able to have access to an ex parte order. So what I would say this year that I learned, which is different, the protective order petition form has been changed recently to include more lines in the petition for the petitioner to express some of the things that Senator Servell is looking to obtain from this bill, right? So I would say that eliminates the need for this bill. If you have a petition that is expressing more of the details of the basis, the act, the date and time, I think that should be enough for notice for the respondent.
All right. Anybody else wish to speak in opposition to the bill? All right. And as noted, this bill rolled out the Senate last year. Is there a motion on the bill? Second. It's been moved and seconded. The bill be reported as amendment. The roll is open.
That's 15-0.
All right. You're doing pretty well.